Page-wise dimensions. Page number 1, item number 1 to 19. Page number 2, item number 20 to 26. Page number 3, item number 21 to 44. Page number 4, item numbers 45 to 48. Page number 5, item number
Item 57, my lords. I'm sorry, my lord. Item 57, my lord.
Yes.
May request, my lord. Item 57.
Yes, what do you want?
Next week, my lord. Item 57 next week, my lord.
You are appearing for whom?
Item 57, my lord. Sorry, my lord.
You are next week.
I am 58, my lord. I am 58.
58 years.
Next week, my lord, I have to file a petition.
Next week.
Item 57 also next week, my lord.
Next week only. Yes, yes.
Oblige, my lords.
Page number 6, item number 63,
My
87.
Lord, I'm sorry, at 61 and 62. Your readings are completed, madam. May I request your lordship to take up next Friday or Saturday? Next Saturday is being a working Saturday.
Saturday is the working.
Yes, madam. 18th, madam. So blessed.
Item 16 my lords. Kindly take up the matter of 2 weeks, my lords. In this matter, the content petition is passed over, my lord. Okay. Yes, my lords.
Page number 12, item number 68 to 99.
Yeah, please. Kindly permit me regard the motion. The matter is that pertaining to the condition of the VRA, said the filed Miller SR number and taken up 230 Miller covered matter. Some district collectors similar, they insist the petitioner similar to join the duties in that, the election.
My lords, this is Ramesh Chila, my lords. My lords, there is a fresh contempt matter, my lord, that's supposed to list today, my lords. It got missed, my lords. Kindly take it up if your lordship convenient time, 2:30 or at least Tuesday, my lords. Millards, that is the police recruitment, Millards. They are proceeding with even though the honorable court judgment is there, Millard, they are going with the medical the antecedent check that the special branch inquiry and all, Millards. And this was filed. The contempt was filed before holidays, Millards.
Yesterday also had said that it was because
No, Millards. That's not the correct the information, Millards. I have filed the even SB inquiry which is in progress, Millards. Tuesday. And Millards, his contempt number is 2486 of 2023. Deeply obliged, Millards.
Lordships, kindly leave, my lord. This is Rahul Reddy, my lord. I'm sorry, my lord. Lord, item 210. Lord, your lordships, in your lordships list. Lord, this is a case where, my lord, notice before admission was ordered. My lord, it is a case of stepping up of pay on par with junior. Junior also notice has been served, my lord. He is also on record. It's not a disputed, my lord, the issue that he is a junior, my lord. All we are seeking is stepping up of pay on par with junior. That's all, my lord. Anytime, your lordship.
my lord, item. Now it is much installment.
My lord, so item 418, my lord. This is pertaining to 317 GO, but only 2 vacancies are there, my lord. We have come to know, we have filed a memo with effect to that, my lord. Next week, the matter will be taken, my lord. In case it does, since 2 years, they are separately. Much obliged.
This matter pertaining to promotion. The economic systems were promoted in AS lordship in 2018. Recently, again, recalled them for head constable lordship.
What do you want?
Tomorrow's list lordship. Tomorrow's. But fourth day, lordship, 4th November gave a promotion again their postings, but they have not considered their service in 2018 to 2023. Lordship. Tomorrow, lordship.
Item number 1, performance report. Sorry.
Milord, item number 138.
138, yes.
Milord, it is a covered matter of Union Bank of India. For the last 10 months, they are not filing the counter. Many times they have taken time for filing the counter. Just to give the direction,
If the matter brings, then I'll give the rest.
kindly list it for Tuesday, Monday or Tuesday, Tuesday or Wednesday.
It will be in the list that is, yes.
Yeah.
Actually, that I should file a conversion with teacher. Whereas, on the date of communication in the order, I am within from stating the limitation. And section 93 of the Tenancy Act describes I should put an appeal revision within a period of 60 days. And
The date the order.
date of the order is 4th February. Yes,
So when will you communicate?
I was communicating. Can you see the page?
What an expecting
Not an expert. We have contested. It was reserved for others. Then thereafter, it was not neither communicated to me nor to my counsel, and therefore, I personally made an application before the authority on 20th/7/2023. Requesting the authority to furnish the order copy, and thereafter, order copy was furnished on 11th August. From 11th August, it is well within the limitation.
So, the delay. Then this will be a reasonable reason, not the reason.
And I'm
Reason wrong.
there
No, but,
are a number of judgments. I'm dealing with the judgment of the Supreme Court. Good judgment and also the some report in.
have you stated in the CRT? The reference by.
Yes, paragraph number 18 of my affidavit. 18 of my affidavit. Along with the suspension petition. There is second, though the input order is dated 4/2/2020, the same was not communicated either to me or to my counsel on record. However, see the unofficial respondents with claiming that the orders would have passed in the appeal. I submitted an application dated 20th/7/2020 before the respondent number 1 seeking the information with regard to disposal of said applicant by its short to furnish a certificate copy. Thereafter, the office of the first respondent has furnished the certificate copy of the input order. So, on 11th August 2023. Therefore, that remains that I was not communicated to the other. Now the judgment of the Supreme Court in 2003, TSHC page number 186. Paragraph 12 may be 14 candidates. How can a person concerned or a person agreed to be expected to exercise the right to review right of review conferred by the provisions unless the order is communicated or is known to him either actually or constructively. The words, the date of the order, therefore mean and must be construed as meaning the date of communication of knowledge, actual or constructive of the order sought to be reviewed. Then the 18th. Reading word for word and assigning a literal meaning to section 48AA would lead to absurdity and so and to such consequences government would have never intended. Provision has an ambiguity and is capable of being read in more ways than one. You must therefore assign the provision a meaning and so read it as would give life to an otherwise lifeless letter and enable the power of people conferred thereby meaning to the avail and effectively exercise. No. That is the reason the next judgment also makes it clear whether the real pronouncements. That is the reason why I have stated categorically stated in my I filed my application on 20th July 2023 itself. Had the authority had really dispatched the order to my council of me, the authority should not have taken that's a fine. On 11th August, that was communicated to me. Again, after 21 days. For the time being, it's only the communication which is the criteria which has to be taken into consideration for the purpose of limitation. Kindly see that the section 12 of the Limitation Act for the moment of how it has to be calculated. The exclusion of the limitation. I'm sorry. What happens in civil court judgments? Whenever the order is pronounced, within the 3 days, one has to file an application. The advocate or record has to file an application asking for the separate order. Then, thereafter, on the date of the preparation of decree and furnish the delivering the judgment, after the delivery of judgment, suppose in a given case of 90 days, the decree is published. That's all. I'm not saying. And so far as authorities are concerned, but they are not, though they say it's an open court pronouncement here, they never pronounce in open court. They only prepare the orders, they communicate to the parties or the council on record. That is the practice. So there is no such procedure.
You have made an application in July 2020.
Yes, because basically on the. That's what.
That's an application. I don't know delay. You still give them reasons. Maybe I don't for I will not delay. Giving
that is to
only from the date of order to an application.
That is to be taken. Then when each and every we receive so many orders from the authorities, even after 1 year also.
The date of receipt. If an order is passed, for example, on 4th, you have made an application within that for this. Then again, the date of receipt, 30 days or 90 days, whatever.
I'm just clarifying that position. So far as revenue authorities and tenancy authorities are concerned, there is no such system procedure to file an application for furnishing the order copy. After reserving the orders, they authorities themselves they communicate to the advocate. That's what, that's the reason why.
Here, it's a sweeper order. It is sweeper require, can't be.
No, it's a tenancy account. Not it. This is a revision under section 91 of the Tenancy Act, 1950. Otherwise, if I don't make an application,
Says, CRP,
yes,
it's a license.
it's a tenancy act. 93 of the Tenancy Act, states from the date of order. That is the reason why my 2003 Supreme Court bullet has categorically stated, unless I know the reasoning given by. And 95 HIGHCOURT also paragraph 12 you also can use for the next statement. The facts and circumstances we stated above, the date of pronouncement of the order in open court by itself cannot be the starting point for the estimation of the period of limitation in the section 15 of the Act. There is also to be shown that the order of the district forum so pronounced was duly signed and dated by the members of the district forum constituting bench. The same was communicated to the parties free of charge. Being so, it has to be appreciated. Mere pronouncement of order in the open court will not be enough, but under the scheme of the rules, copy of said order was also to be communicated to parties affected by said order, so that the party adversely affected therefrom may have a fair and reasonable opportunity of knowing the text, reasons, and content thereof, so as to formulate grounds but are before the appeal or the higher forums. In the absence of such communication of signed and dated order, the party adversely affected by it will have no means of knowing the contents of the order, so as to challenge the same and get it set with the applicable authority of the higher.
Beg to represent your lordship. Respondents are not implementing the orders passed to consider the representation dated 30/4/2023, your lordship, within a period of 4 weeks. Page number 12, your lordship. Order is advised.
Okay.
There's 4 weeks.
Milord, your lordship passed the orders in the month of June, Milord. Till the date, they were not complied, Milord.
So that we-
Yes, Milord.
Item number 4, education partner. Item number 1.
May it please your lordship. The order passed by, final order passed by your lordship, page 11. 11th portion at page 15. Yes. The direction read only because he is due to retire on 31/12/2030, 23. Director member to, because they have not implemented. They have not implemented. Yes, madam. The CEO Malad has passed that order, though he was a degree holder, but he has changed his, deleted his name finally, and then included some person who has intimate qualification. He made several representations, then he went to the Human Rights Commission. Human Rights Commission issued notice. Then CEO filed some letter that was rejected by the Human Rights Commission, directed the district collector to file a report. District collector filed a report saying that it is true that his name was deleted, though he is a graduate and some name was included. And directed, because it was a Mulugu district, he requested the Human Rights Commission to direct that CEO because he is other district. Now he is transferred to the Warangal district. He made a representation to the district collector. Narrating this. Therefore, your lordship will take into consideration of the report of the district collector, Mulugu, and not directly the district collector, the Warangal district, who is the competent authority to pass orders. They have not taken any action. I sent the notice also. No, direction petition I will not place, because he is due to retire. He is due to retire 31st. Obliged.
May I please, madam? Order, Milad, page number 8, Milad. For the presentation, Milad, not pass any orders, Milad.
Seen it appearing online also.
Yes.
This is, my lord, this is a contempt lordship can recall that despite your lordship's order, your lordship, would you, your lordships could hear me, my lord?
I'm able to hear you and post the wrong definitions of the stability. And
Let the notice go, my lord. Because though they have subsequently amended the withdrawn, during that period there is still contempt.
it's the wrong, the proper code.
Or lordship may post it along with the red petition.
That's what I suggested.
Yes.
Audible your voice.
No, but then they have to know that there is a confusion. There are please. Yes.
May it please your lordship?
Yes. Yes. Yes, Mr. Vikas.
My lord, Respondent willfully disobeyed the orders passed by this honorable court in WP number 39017 of 2022 dated 29/10/2022, my lord.
All right, no dates, 4 days.
Item number 10, just one.
For non-compliance of the orders passed by this honorable court, page 10 is the operative. The direction was to come to for compilation of funds within a period of 2 months, even up to 3 months. Right.
Lord, order is at page 8. Relevant portion of page 9, bottom to 10, Lord. Learn is 9. Learn on special government pleader appearing for the response submitted to the petition will be permitted to continue the present school and submitted the petitions till the so and so. Till the final publication of the result, electoral rolls, he should not be transferred. But before that, Lord, he was transferred and posted to some other place. That is violated the court. Deliberately they issued a transfer on it, page 18. Thereafter also publication of results 31/10.
Instead of not paying the same amount of work that has taken another way, the legal expenses incurred by the respondents towards the council for SFC also they will have to salary. The correspondence is being made by the respondents 3 and 4. But though they were not respondents in the main literature matters, because they are corresponding with the petitioner are significant. Yes, that's the letter that the petition has read around just 21, 22 of the day. Yes, ma'am. Page 20 is the letter addressed by the executive director. Page 20, madam. Yes, madam. Page 20 is the regular director. Name is Shiblal. Page 20, you are the executive director. Yes, so I'm sorry, but all of them are letters to the page 44. Sorry, madam. Page 44. Page 44, madam. This is by the executive director to the petitioner. They say, my lord, with reference to the above, we write to inform you that we have already attained legal superannuation as of 31st as per the order number so and so. We have approached Honorable High Court and obtained interim direction to continue beyond pathway and also by stating that petition and saying standing. Therefore, your payment of salary beyond the 30/25/23 is subject to further orders to be passed. No, but he is not part of the writ petition and now we have responded to the petition representation. So I'm just a need to make him of the party. Notice.
May it please. Milord, adjournment petition, Milord, was dismissed by the trial court, Milord. It's an adjournment, but in fact, it is an enlargement of a time for the compliance of the order, conditional order passed by the trial court. Should may kindly take, Milord, the DW 1 to 3 were evidence was issued earlier. Yes. Milord, the reason is the health. On the health ground, Milord was suffering with fever and some motion, diarrhea. That has been stated in stage of the trial won't come in. Nothing, no prejudice would cause to the other side if it is allowed only once per, just a minute. Only once. Because the conditions or the conditions imposed by trial court in the earlier petition, the cost was already paid. The second condition that they must produce the DW 123 and the next date of hearing, that was not because of this reason, health ground, they sought for adjournment 151 million. That was dismissed by the trial court that no medical certificate was filed. Any of the suit can be decided on merits instead of ex parte judgments only trial stage. Dependents, petitioner dependent. Plaintiff only has not filed any counter milad, orally opposed. Yes, adjournment, we lost my kind, page number 6, milad, the docket art. Oppose the petition strongly on various grounds, but no counter was filed. Only orally opposed, it can be, it's not a big issue. One. Some condition, lodgement kindly impose some condition. Next date of hearing, they will produce all the witnesses TW 123. Only non-compliance of the earlier order. Idea, dismissed. Then posted for the arguments. It's posted for the other day it was posted, but thereafter I don't know the next date of hearing. The other day it was posted. Might have been one. Lordship may kindly pass short pass or I'll contact the short pass.
Lord, I am on online. Yes. Lord, I am for the defendants in this matter. We gave it petitioner. Lordship, I request for 1 week time, my lords.
Okay.
And they are served, my lords. The issue is.
Okay, my lord. Let it be next week.
Public.
Much of.
Thanks, sir, Minister. Matter pertains to the mat granting of the family pension lordship. The petitioner husband worked as a ASI in the Home Department lordship up to 31/1/2012 and died. First wife lordship. She is petitioner before lordship is a first wife. At the time of in service record, first petitioner name was entered in 1977. Thereafter, the husband, the Bhadrata membership in from nomination 1978, fourth respondent name was entered lordship. No. Yes, lordship. Yes, lordship. The fourth respondent also not claimed. Double.
That was state.
21.
Item 16, my lord, if Ramesh Chilla matter, my lord, I am appearing online.
Yes, yes.
My lord, my lordship voice is not at all audible. My lord, Ramesh Chilla's matter.
Yes.
Item 16, my lord. Yes. It's a child, women child development project appointment, my lord. The matter is pending with the
inquiry, sit.
Okay.
My lord, the sit report comes, my lord, we are ready to give appointments. Your lordship may adjourn by some time, my lord. So that
Next week.
yes, my lord. My lordship audio is not at all. Yes, sir. Next week, my lordship may take
Oh,
up.
deeply obliged, my lord. Deeply obliged.
Yes, that's correct.
Next week.
The petitioner will are working as the village revenue assistant. Will that what matter in that number?
My lord, sir. Ramesh, my lord.
Yes, I have to.
I'm sorry. I'm sorry. There is a conflict of the numbers, my lords, in the other court, my lords.
All right, no, your matter.
My lords.
Here is next week.
My lords, if your lordship, this one, my lord, the 15th, the November 15th, there is other matter that's on CDPO. That's the Child Development Project Officer. That is also coming, my lord. These can be tagged with that one, my lords. If your lordship, because they filed the counter also, my lords. In counter, they clearly mentioned that no, there is no whisper about any leakage or anything about that particular 2 examinations, my lords. So those 2 examination results can be announced, my lord.
All right, 15th,
Yes, my lord, 15th.
Yes, my lord. Okay.
I'll provide the numbers to the court officer, my lords. Obliged, my lords.
Item 17.
May I please? The petitioner Millard is working as the village revenue assistant Millard. To calculate the village revenue assistant Millard in covered matter Millard. Page number 50 Millard. The same order may be passed to me. 20th October 2023. Yes.
Item 18. Services.
I'm appearing through online.
Yes.
Appearing through online. And all the petitioners mirrored in this case mirrored working as a art, craft, drawing, and music teachers in government ZP and MP schools, mirrored Mandal Parishad schools in Telangana on contract basis. Mirrored the respondents mirrored did not pay the areas of salaries during the Corona period, which is contrary to their own guidelines, mirrored. At page number 92, may kindly go to mirrored.
Period from when?
Page number 92.
90.
92. This action, Lord, is contrary to this GO, their own GO, Lord. Lord, this is not kindly allow me to.
I'm asking you the period for which you have not been paid back.
But I'm not able to hear, Malad.
I'm asking you about the period for which you have not been paid back. Are you able to tell me?
Lord, a similar matter, my lord. Similar matters already admitted, my lord. Already counter also filed. Can be admitted this case, my lord, for their counter independently.
Okay. Stop.
So audio is very poor, my lord. Could not be able to hear, my lord. It's a problem.
Item 19.
Deeply obliged.
Eight is your lordship. Your lordship, the petitioner in this petition is seeking a direction to consider his applications for appointment on compassionate grounds. I am the petitioner, your lordship, the petition adopted daughter of the employee. He doesn't have any issues. He doesn't have his wife. Yes, your lordship. I was adopted in 1999 through a registered document which I have filed at page number 10. Yes, your lordship, I have applied in, not yet rejected, they are pending. I have applied, my petitions may be taken in consideration at page number 34, 36 and 37. Page number 36. She was a small child when she was adopted. She made the application in the year 2021 and 2023.
The main prayer is to Milord to set aside the class 2 of the GO 612 of dated 1991.
And direction to consider application. The direction may be given to dispose of the petitions. That's only because there is a clause of more than 5 years adoption should be there. That's what I have to. Yes, Your Lordship. Definitely, Your Lordship. Yes, that's what that will. Wait, oblige.
R1 to R3 has stopped my regular pension. It's a regular family pension. Due to, they have stated that they have excessively paid to me. That's what they have withdrawn my said pension amount from my SB account. R2 is none other than a State Bank of India, where is my account is existing. And the pensioning officer is a R1. As they have stopped my payment, and moreover, they have withdrawn my existing balance amount also. It is in the month of September. When I went to draw the amount, there was no balance. They have stated they have paid the excess amount, that's what they have withdrawn. No orders. My Lordship. My Lordship, in between this, the amount may be restored in my account, my Lordship, which I can, because my existing amount, my Lordship, my present existing amount, I'm not asking the continuation of my pension, my existing amount have withdrawn. Yeah, they have withdrawn, my Lordship, that's what. State Bank of India was R2. Okay.
It's here. I take notice and we have second respondent for one. Second respondent, a similar case, we have conducted in Supreme and the Sanapur of apparently award passed. What is perhaps
Award is-
according to the order, 60. And 50 employees, they went to 60 labor division with the and whether they are a workman or not, labor could have to decide. Labor could decided they are performing. They are being paid benefit, whatever.
Definition is, we have challenged the 75% of wages was granted by the labor court, my lord. And as per the service regulation, my lord, they have to superannuate in the age of 58. That labor court held that up to 68. I will serve the papers, my lord. Similar matters. That they have filed the one judgment of the division bench, my lord. My humble submission is that is not applicable for me, but this case is concerned. I have placed before my lords. I will serve. Next, last time I kindly posted in motion list, my lord, but the next.
They have used casual labor. If without later on was transferred to Chhattisgarh. In 2010, he developed a new joint venture. He requested the authorities to give him light duty. The authorities were pleased to give him light duty for 2 months. And now, at present, due to old age, is not able to work on heavy vehicles. So he requested permanently the light duty. Instead of giving light duty, they are stating that you are absent from 55 days. And the was served to the advocate who was defending my case in 2014. Even after dropping to notice of the authorities, they did not consider my request. Simply they rejected my petition and third. Year 2021.
December 1. Dated 1/10/21.
21 months.
Yes.
Yes.
May I please your lordship. The present petition is filed playing the honorable court to direct the official respondents, my lord, to consider the representation for conventional appointment, my lord. And the presentation was submitted on 9/10/2023, my lordship. My lord, the petitioner is an employee joined in the year 1987, my lord, and he was declared medically invalid on 30/4/2022, my lord. 2022, my lord. 34/2022. It's in page number 8 of my. Yes, my lord.
If he made below 35 years and he goes 35, 18 to 35 years, in the case of the page 14, 14 to 20.
My lord, my only submission is, yes, my lord, I am challenging the rejection order. It's there, my lord. In my representation, clearly mentioned. Yes, my lord.
They have already concerned.
My lord, my only. Again, I will amend the prayer. My lord, my only submission is there is a service record, my lord. As per the service record, the petitioner son is having only 34 years, 4 months, my lord. As on. Oblate. Oblate.
Attended the board climbing test as per notification 2nd February. As per intimation level in 2020. There is a discrimination between the test, which is at exhibit page 46, my lords. The others was given a support of a ladder climb. In similar set of circumstances, your lordship was pleased to pass notice before admission. District also is forced along with that and take out a personal notice.
Supporting what is right. Line by post with the ladder.
That is how they have conducted. That is how they have conducted.
But your procedure also adopted for you from the procedure. How can you provide a ladder for employees? Can you do this?
He's already working on daily wages basis. They are provided to him, but does it not provided to me? That is what my content. That cannot be discriminator. The officials showing the discriminatory between one to other. That is what my father said.
But still, single man student a lot of part of this for movement gets
And for R1 minute.
Appointment to the end of appointment. Specifically fourth respondent.
That is the reason we are getting instruction.
I mean, subject to their counter. Let them verify.
Similar matter. So next week we get some other date. Some would post along with that million meanwhile are getting instructions. So they are challenging fourth respondent appointment challenging. Don't charge for part.
They said this will not call for the records, Mallards. Let it be accepted by all. Call for the records, original records, so that it.
This is not opening this.
Because the film is like sample. I can load this film and get the instruction film next week will take it up.
Can say across the line.
Why are you making by doing such things? How can anybody have any confidence in doing it? It's examination. See, pictures may be different for that. Do not explain anything as this is the case, then how can anybody in this system have any faith?
Next week we will instruction. Yeah.
It's not still, not like call for the records.
Stop the 2 weeks. If you find whatever that itself is enough.
But-
That states the entire problem. I see. Not how it's done.
I was waiting for smart services.
May it please your lordships, beg to present this case on a virtual mode, my lord.
Yes.
My lord, petitioner herein has placed a complaint against the fourth respondent that the fourth respondent has impersonated the petitioner and has obtained the job in third respondent department. Pursuant to my complaint, my lord, an inquiry was conducted. Inquiry is at page number 16, my lord. Now my grievance before this honorable court is that, my lord, during the course of the conducting of this inquiry, my lord, the complainant, the petitioner herein was not put on notice and an opportunity of personal hearing was not given to the petitioner. So my limited prayer, my lord, what I am seeking before this honorable court is that, my lord, till the final orders, the adjudicatory department has not passed the final orders pursuant to this inquiry, my lord. So notice may be given to, an opportunity may be given to me, my lord, before passing the final orders on this inquiry report. 17 is the page 17, my lord. I beg your pardon, my lord, I am not in a position to hear the voice of the lordships, my lord.
First and third respondent, I am appealing. Please letter forwarded to the second respondent, that is district collector, as to answer.
Okay, instructions we have already answered. He wants to know before you take a final. Next week.
Three. 1 and 3 minutes.
Lord, given by the major punishment orders, my Lord, I am challenging, I am approaching the Honorable Court. I filed an appeal, my Lord, appeal also rejected. Your Lordship may issue notice, my Lord, is it? Major punishment. Obliged.
This matter was posted to 2111 for defendant's argument. 2111. Witnesses. The CRP is allowed, my Lord, if it is disposed, I can produce the witnesses on the next date of hearing, my Lord. With that condition, this can be disposed of. Stay. Stay.
Seven to 56. Special and practice. Accountants comes.
But I'm not able to hear.
Yes, you. Yes. In that your what the pen they have the also directed produce the status of the list. How many vacancies are there in the data? So they are not producing. That we are also the so the content is still pending.
And here,
But then, now,
extended advanced. I will record this and proceed. Yes. Yes.
Milorship, interim orders are complied, Milorship. From in Ramu Milorship, he became a GP. Yes, Milorship, we will inform. Okay. Copy. Yes, Milorship. This is condition. We consider him not because his wife is suffering with severe asthma and his mother passed away not with cancer. She was undergoing cancer treatment at South. She has given so many representations. She could not bring her. Unfortunately, she passed away. Now his wife is there with severe asthmatic attacks. Finally, his case may be considered humanitarian. Yes. Your lordships, I am trying to convey that.
Yes, maybe.
Much.
31 date not considered.
I give in a liberty.
let your lordship pass the interim order in this writ petition that because of our mistake in IA prayer is mistyped in Rangareddy district. Petitioners are belonging to Warangal and Karimnagar blood. Entire prayer and affidavit is not stating about the Rangareddy district. Maybe please to delete the Rangareddy in Rangareddy district. It may be general order. Yes, your.
Yesterday, my lordship also passed it. Yesterday.
But I appeal. Petitioner, there is an interim order passed by your lordships on 4th October 2023, extending it till date. Counters have been filed and reply is also filed. Matter may have to be taken up for hearing. Next week, anytime, I am ready.
This one. This one. See, like, coming offline is far better than.
I get next stage.
I have 43. Objection and Sami. Education.
My please, your lordship. Interim orders has to be extended, your lordships. Counter is also not yet filed.
May it please, your lordship. The interim order expires today as a vacate petition has been filed by the respondents. That's the interim order, not to proceed with the interview. Interview was scheduled for shortlisted candidates. We were aggrieved by the list of shortlisted candidates insofar as a petitioner was not included. That's when we moved a lunch motion and sought an interim order. Interim order was granted not to proceed with the interviews. That's where the status is. They said they have completed, but they have not released the result. No, my lords, no.
As per the
WebEx Assistant is capturing notes.
Miller. Has come before this court on the day of interview. By that time, order of statement immediately extended. By time it's from interviews are going on in a lot of which courts were not allowed. They have proceeded with the interview. But after receiving my case, I was from the office of the case and they have yes, Lord. We have advised them not to publish the results. That is why your lordship speaking will hear the matter and decide the matter was responsible because the appointment of director has been started. Your lordship, there is no director since 2022 and now the constitution start by
I'm ready to argue, my lords. If on merits, I'll present my.
I am appearing for the fifth respondent, my lord, the corporation.
Yes. My lords, if Mr. Raghavacharya is addressed, if he's able to hear, maybe in the mic, my lords. If it's not. Probably not, it's probably not.
Otherwise, township.
My lord, I may permitted to appear in a hybrid method, my lord.
Are you able to hear me?
Technical matter. It is one.
Technical issue. Able to hear me?
Let Ratna argue. My lord, I'm unable to hear your lordships, my lord. If I am audible, my lord, I would like to make only one submission to your lordship.
Yes, yes.
My lord, since 2020, there is no director personal to the corporation. I am appearing for the corporation. My lord, I have raised a preliminary issue, how the writ petitioner obtained the personal files of the other parties. He has not answered in the reply. In any event, my lord, to put quietus to this issue, the grievance of the writ petitioner is that he is not called for interview. Your lordship may hear all the parties concerned, and so far as corporation is concerned, if your lordship direct this PSP to interview this person also, I cannot come in to go. We are in the limbo manner for the past 3.5 years, and some reason or the other, there is no director personal to the corporation. I humbly pray your lordship to pass final orders either way, my lord.
Are you able to hear me now?
Yes, madam, I am able to hear your lordships now.
Very well, madam.
Ready to argue the matter? Are you ready?
Yes, my lord, I am ready.
Very well. Well, let's the post which is under consideration is director personnel in a public sector undertaking called NMDC, which is respondent number 5. For these public sector undertakings at the level of directors, just a background as to, because the guidelines and all, they are not in the usual rules. That's why. And so for Prime Minister's office gives a, the
WebEx
appointments committee gives a
Assistant is
go ahead, the
capturing
appointment
notes.
is done. So it's given in a sealed cover. If that is not agreeable for whatever reason, the next best, that's the broad procedure, my lords. So here for respondent number 5, the post of director personnel with respect to human resources, that post fell vacant. It fell vacant in 2020. But for reasons best known to the respondents, they didn't bother to fill it till August 2022. Much is being said about the post having been vacant from August 2020, but kindly see the vacancy circular, the advertisement, it's at page 27. Page 27, my lords, your lordship will see the date on the right-hand corner. It is dated 38/2022. This was when the circular was actually issued, whereas the date of vacancy, just 3 lines below, date of vacancy is 1/8/2020. For 2 years, they have, for reasons best known to them, that's no, because both the councils had said that, since 3 years, where is the deal? That's the, be that as it may. So this is the advertisement. Now, my lords, in this advertisement itself, while we are on this, I'll point out 2-3 provisions which are relevant for the adjudication. Now, your lordship, the date of vacancy is important for some other reason also. That's the reason why I also pointed out why it is 1/8/2020. The post is director personnel. Kindly turn over leaf to page 28, paragraph 4. Experience. The Applications eligible as per the criteria prescribed in the vacancy circular should not be withheld by the CPSC or the Administrative Ministry Department, State Government. Then, so and so this paragraph would reveal that the whatever is advertised in the vacancy, whatever is the eligibility criteria that is advertised, that will be strictly have to be complied by the CPSC, means the public sector undertaking, as well as the board. This is what this guideline says. Now, how many candidates they shortlist? That is at para 8. Your lordship will see the applications are considered and shortlisted with reference to the job description and eligibility criteria in the following manner. Internal, 6. Internal means, my lords, if NMDC, for example, NMDC is the applicant. So they'll shortlist a total of 12 candidates for consideration. 6 of them will be from internal candidates of NMDC. Sectoral means in a similar public sector undertaking someone else. External means other from the central public sector undertaking, someone has an experience in other private organization or something, and central government, private sector, state PSC. This is how it is done. So in the shortlist for the candidates, ultimately NMDC candidates, 6 of them must be shortlisted. That is the relevant portion. The rest of them I'm not concerned. The petitioner vacancy is 1. Vacancy is only 12 candidates. Yes, 12 will be called for the interview. They'll take 1. So the petitioner here is from NMDC. He was all through working in the human resource department. His entry and all through he was working in the human resource department. And I showed to your lordship the condition in the advertisement, para 4, which says that you must have 5 years of cumulative experience in the last 10 years. Now, your lordship may kindly see the petitioner's application form to show his eligibility criteria. Kindly take page 33. The petitioner's eligibility, 33, balance, 33. At 35, this is what he has done. I'll take from below, my lords, the column number. Yes, just to demonstrate, because I need to, as a petitioner, I need to demonstrate. Anyway, okay, that is agreed. So for the last, not just last 5 out of 10 years, 10 out of 10 years, he was working in the HR department itself. There's no grievance on that. Now your lordship may see the respondents number 6 to 8, the unofficial respondents, who have also arrayed as a party, to whom notice has been served and they have chosen not to appear. 6 to 8. Now your lordship may see why they have been arrayed. Your lordship may kindly see the impugned letter, which is at page 25. Page 25, this is by the respondent number 2. It is dated 30/6/2023. This is the call for the interview. Public will consider selection for the post of director personnel at 3:30 to 5:30 on 14/7. The selection meeting will be conducted through video conferencing. Kindly see the candidates. Candidates 1, 2, 3 to 6. These are the internal candidates. I am not concerned with 7 to 12 because they are external candidates. I have no grievance against them. Now candidates 4, 5 and 6, they are from the human resource department itself. And within the human resource department, they are seniors to the petitioner. So I have no grievance against them. But the candidates 1, 2 and 3, these candidates, in my humble submission, do not meet the qualification under para 4. They do not have 5 years of experience. This fact can be gathered from their own applications, which I have filed along with IA2, my lords. Kindly have IA2. At the time of moving this matter, my lords, at the lunch motion, I had to give these papers across the bench because I did not get them immediately. Now I've filed them as IA2. Your lordship has IA2. Kindly take page 15. Page 15 is Mr. Sanjeev Sahi, who is in that list, in the short list number 3. Sanjeev Sahi is from NMDC. Kindly see his experience at page 17. He has been Chief Manager, Donimalai Complex. First, below that, Chief Manager Production. Below that, Joint General Manager Production. Before that, Joint General Manager Production and Mining. Nothing to do with HR. Next, my lords, at page 22, Mr. K. Praveen Kumar. His experience is at page 24. Mr. Praveen Kumar is shortlisted candidate number 2. 24 are his qualifications. One is Executive Director, Personnel and Administration, but your lordship will see this is from 1/8/2022 to 30/8/2022. Just before the vacancy even arose. I omitted to point out, my lords, because what is relevant is the date of vacancy. Below that, Executive Director, Personnel and Administration, again, 17/3/2021 to 31/3, before the date of vacancy. Chief Manager, Administration, 21 to 22, again before the date of vacancy. Below that, Chief General Manager Law, Joint General Manager Law, Commercial. My lords, firstly, the first 3 columns, he doesn't have. Even the first 3 columns cannot be considered as even 3 years because that was not on the date of vacancy. So he never, for the purpose of this post, he has no. Then, my lords, the last, page 29 is the first candidate who is shortlisted, Mr. Sahu. His experience is at page 30. Executive Director, Donimalai, General Manager, Karnataka, Joint Manager, E7. There's no experience. These are all, my instructions are, these are all candidates who are purely from mining background. Your lordship will see at 29, your lordship may just turn back 29. This person has experience only in mining and MBA administration. MBA, he's just an MBA. He's neither qualified in personal department nor did he have the experience in the qualified. That's how, my lords. Now, my lords, the proposition of law settled. I'll place judgments before your lordship. What is advertised, that cannot be deviated from. Because the very purpose of a fair and transparent recruitment process will be defeated if advertisement is something and the criteria adopted is something. The advertisement is categorical. It leaves no scope for any doubt. That 5 years out of the last 10 years, you must have personal. These 3 candidates do not have it. So then the question would arise, how were these 3 candidates shortlisted? So therefore, this is my ground for challenge, saying that these 3 candidates were not eligible. They could not have been shortlisted. Once these 3 candidates go, the petitioner here is in seniority number 4 in the HR department. He will straight away get an opportunity. Whether he will ultimately get selected or not is a different question, but his opportunity has been denied. Therefore, Article 14 and Article 16, that is how I am before your lordship. Now, my lords, just one small point I had omitted. I'll just very. Your lordship may kindly take the guidelines for a moment, which is at page 53 of the writ petition. One small important paragraph I just missed out. I just want to bring to your lordship's notice. Page 53 begins. Kindly see page 64. Page 64, cutoff date for determining eligibility. The cutoff date for deciding the eligibility of the candidates is the date of occurrence of the vacancy. So whatever is the law, is the advertisement, whatever factors have to be considered, they must be as on 1/8/2020, nothing thereafter. This is an important aspect. I am highlighting this not only for the case of Mr. Praveen Kumar, where I pointed out that he became an HR person only later, but for some other aspects also, I am highlighting this point. Right. Now, so when this was highlighted to the Leonard Single judge at the time of admission, on the basis of this, the interim order was granted not to proceed with the. So your lordship would have seen the interview was scheduled to be between 3:30 to 5:30. Lunch portion it was taken up. The order was passed at 3:25. It was communicated. Now, my lords, kindly see what do they say in the counter. In the counter, they admit that this letter was never given to me. They say that because you are not a shortlisted candidate, there was no reason for us to give you a letter. That is the reason why the petitioner got to know on 11th or 12th, and he could only move a lunch motion. It is not as if this impugned letter, my lords, it is dated 36. because it was said that, at the 11th hour, as a lunch motion on the date of the interview had come, the reason why I had come in the 11th hour, they themselves admit that they have not given, they admit that your lordship may kindly see counterfeiler, the respondents number 1 to 4. Yes, my lords. That IA is also there. Perhaps IA3, my lords. It's, yeah, wait. Now, my lords, they admit that communicated to the Secretary, Ministry of State, so and so, and private candidates were shortlisted. It is further submitted. There are which are. This is fine, but they admitted they have circulated it to the private candidates. Then they go on to say that the petitioner is at the 16th position in the eligibility seniority list. From where they get this eligibility seniority list, I fail to understand, because nothing is annexed. Because then it may be 16, but they've not even shown any proof of that. In the same paragraph, my lords, going below, wherein the petitioner is leveled at 16th position in the eligibility seniority, and due to the limited slots, the petitioner was shortlisted. This is what they've said, but they've not annexed any document. In any way, this assertion is of no relevance. The reason being, once my argument that only candidates who are in the HR department have to be taken is considered, then this seniority will not be relevant. Because if they're considered for the whole of the corporation, then it's a different. So, my lords, that's why they've said that they've sent this letter only to the private candidates. So that's an admission. Yes, with respect to that. Now what? Kindly see immediately para 9. Now they bring up a new plea. Your lordship may kindly see. In replies to paras 10 to 12, it is submitted that the shortlisting of board level selection is done by the respondents, that is PESP, as per the prescribed procedure and guidelines, which is being followed from time to time. For the post of director HR person, apart from the experience as given in the job description, the criteria spelled out in the internal guidelines of the PESP dated 4/2/2022, which is Annexure 2, is strictly followed. It is submitted that the said guidelines have been duly communicated to all Ministry Department of the Government of India and the CPSC while proceedings dated so and so, and the same are also available in the PESP website. The PESP has divided the candidates for HR person post in the following 3 categories. Category 3, applicants, your lordship, instead of this has not been paraphrased properly, I'll take your lordship straight away to Annexure 2. Annexure 2, which they rely on, the internal guidelines, which is that they have not, in the vacate petition handed to me, there are no page numbers. Annexure 2. Yes, mine was given without page numbers. Be the minutes of internal, I got. Minutes of internal meeting dated 4/2/2022 regarding shortlisting criteria for the post of director. A board meeting to discuss the shortlisting criteria for the post of director person was held on 4/2/2022. During the meeting, the following 3 categories of applicants were clearly defined and agreed upon. Category 1, priority to applicant with 5 years experience during the last 10 years in HR, IR personnel. Category 2, applicants with minimum 2 years experience in HR, IR personnel, plus 3 years as functional head of projects, plants, having direct eligibility responsibility of 1,000 workforce. Category 3, applicants having experience as functional head of projects, plants, having direct responsibility of at least 20% of the workforce. So from what is advertised is only the first category, but they say as per their internal guidelines, they have these categories 2 and 3. Now, what is the breakup of this? Your lordship will see that under para 2A, during the meeting, the board also discussed matters pertaining to the distribution of the 6 slots. allotted to internal candidate. It was agreed that 3 slots will be allocated to category 1 and other 3 slots will be allocated to category 2 and 3. It was also decided chairperson will work out the details. Accordingly, the following principles for shortlisting have been followed. The 6 slots allocated for internal candidates will be distributed as per the following details. 3 slots will be reserved for category 1. Next 3 will be distributed to applicants from category 2 and 3 in the following order of priority. First priority category 2, second category priority 3. So this is what apparently they have followed. That I had pointed out, Mellots, in that impugned letter. 1 to 6, 4 to 6 are from the HR department. They have the 5 years. So purportedly 1 to 3 who are shortlisted, they fall under categories 2 and 3. Even though they don't have 5 years of experience in HR, but they fall under category 2 and 3 where you don't need 5 years of in that department for the last 10 years. That is the explanation. Now the question before your lordship is whether reliance on this internal meeting is valid. Whether it is open to the respondents, having stated in the advertisement only category 1. In fact, they don't even say category. They just say person to be eligible must have 5 years of experience in the last 10 years. That's all they say. They don't even refer to these internal meeting guidelines in that. This is dated 4/2/2022. The advertisement is August 2022. If at all, by reference, they could have done it. They don't do it. Nothing is said about category 2 and 3. Whether it is open for them to rely on what is admittedly an internal meeting. If it is an internal meeting and merely because it is given publicity, whether that becomes something which can be followed and whether that is legal is a position that your lordship will have to consider in this matter. Now, my lords, the law on this position, on this, is quite clear in my humble submission. My lords, there's a few judgments on this aspect. May I just... Instead of having to give judgments individually each time, I've just made it like a compilation. And there's a note also, my lords, but however I'm arguing it, I'll not trouble your lordship with the note. Kindly take the first judgment in that, flagged 1, which is Bedanga Talukdar versus Saifudullah Khan. The proposition of the law, my lords, is that whatever are the eligibility criteria advertised, they need to be strictly followed. The Honorable Supreme Court goes to a further extent and says, even if the statutory rules give scope, say that something else must be the qualification, they cannot be followed if it is not advertised. There's a one step further. The statutory rules, even if they say that they have to follow, so this, my lords, your lordship, the relevant paragraphs, your lordship may straight away take paras 29, 30 and 32. May I read 29? We have considered the entire matter in detail. In our opinion, it is too well settled to need any further reiteration that all appointments to public office have to be made in conformity with Article 14 of the Constitution of India. In other words, there must be no arbitrariness resulting from any undue favor being shown to any candidate. Therefore, the selection process has to be conducted strictly in accordance with the stipulated selection procedure. Consequently, when a particular schedule is mentioned in an advertisement, the same has to be scrupulously maintained. There cannot be any relaxation in the terms and conditions of the advertisement unless such a power is specifically reserved. Such a power could be reserved in the relevant statutory rules. Even if the power of relaxation is provided in the rules, it must be mentioned in the advertisement. In the absence of such power in the rules, it could not be provided in the advertisement. However, the power of relaxation, if exercised, has to be given due publicity. This would be necessary to ensure that those candidates who become eligible due to the relaxation are afforded an equal opportunity to apply and complete. Relaxation of any condition in advertisement without due publication would be contrary to the mandate of equality contained in Article 14 and 16 of the Constitution of India. A perusal of the advertisement in this case will clearly show that there was no power of relaxation. In our opinion, the High Court committed an error in directing that the condition with regard to submission of the disability certificate, either along with the application form or before appearing in the preliminary examination, would be relaxed in the case of the respondent number 1. Such a course could not be permissible as it would violate the mandates of Article 14 and 16 of the Constitution of India. Then 32, my lords. 32, I'll read from line 3. It is settled law that there can be no relaxation in the terms and conditions contained in the advertisement unless the power of relaxation is duly reserved in the relevant rules and or in the advertisement. Even if there is a power of relaxation in the rules, the same would still have to be specifically indicated in the advertisement. In the present case, no such rule has been brought to our notice. In such circumstances, the High Court could not have issued the interim direction to consider the claim on the basis of identity card submitted after selection process was over with the publication of the selection list. My lords, in this case, the principle is analogous. What has happened is the advertisement specifically stated, but in a particular date, it has to be done. There is no reservation that they could relax it. The rules also did not provide. It's the same principle, my lords. Going by the same principle, Sanjay, the next judgment, it just reiterates at para 11 and 12. Para 11 and 12. 11, my lords, in fact, 11, I did not bother your lordship with the whole thing. In fact, the Bedanga Talukdar is extracted in this. Then in para 12, what is said is, we are in respectful agreement with the above judgment of this court. Exercise of the power of relaxation without informing the candidates about the existence of such power would be detrimental to the interests of others who did not possess certificate and did not take in the selection process. We are unable to accept the submission that selection is on the basis of the performance of the candidates in the interview, and that the DOS certificate is not an essential requirement. The rule as well as advertisement provide for submission of the certificate at the time of interview compulsorily. The rule further provides for production of the certificate as an additional requirement for selection. The above stipulation in the rule as well as advertisement cannot be ignored. Then, my lords, the third judgment, this is in fact straight on the point. It doesn't even, this is PM Lata versus State of Kerala. What happened in this was for the post of teachers, what was the prescribed qualification was TTC, there was a qualification. But B.Ed candidates were allowed to, the Honorable High Court, the High Court there, it said that they could not have done it, but nonetheless on the ground of equity, they said, they can be considered. Kindly see para 3. By the impugned judgment dated 18/2/2000, the division bench of the High Court in writ appeals and urgent writ petition preferred by the B.Ed candidates upheld the decision of the learned single judge that under the terms of the advertisement, the B.Ed candidates were not qualified to compete for the post. Despite this, strangely, it upset the directions made in favor of the present appellants as TTD's candidates because of an undertaking given by the state of Kerala that they would submit the relevant portion, your lordship, is at para 11 and 12. The division bench in the impugned order upheld the decision of the single judge that in terms of the advertisement, B.Ed candidates were not eligible to take up selection and to be included in the rank list. We failed to understand that having thus upheld the decision of the learned single judge, what was the justification for the division bench to refer the statutory criminals applicable to teachers in private or aided by government and judgments in their cases for reversing the judgment of the single judge and maintaining the rank list, including names of the B.Ed candidates and their appointments on the basis of rules yet to be framed. Then para 13 is important. Equity and law twin brothers, and law should be applied and interpreted equitably, but equity cannot override written or settled law. The division bench forgot that in extending relief on equity to B.Ed candidates who were unqualified and yet allowed to compete and seek appointments contrary to the terms of the advertisement, it is not addressing the injustice caused to the appellants who are TTC candidates and would have secured a better position in the rank list to get appointment against the available vacancies had B.Ed candidates been excluded from the selections. In this case also, my lords, if at all equitable consideration were to be argued, where is the equity in favor of my client who has throughout his career worked in the HR department, not just 5 out of the 10 years, what is the justification for him being excluded? The next judgment follows this. Indresh Kumar Mishra, here my lords, your lordship straightaway may take para 21. In the present case, the educational qualifications required have been specifically mentioned in the advertisement. There is no ambiguity and or confusion in the advertisement providing educational qualification and the post for which applications were invited. History, civics. There cannot be any deviation from the educational qualifications mentioned in the advertisement. Once having found that the respective writ petitioners appellants herein were not having the requisite qualification as per the advertisement, namely the postgraduate bachelor degree in history, which was a requirement as per the advertisement, and thereafter their candidature was cancelled. Both the learned single judge as well as the division bench of the High Court have rightly refused to interfere with the same. What happened in this was, my lords, the candidates had degrees in some other general arts degree where they had one paper of history or one paper of civics. They said that it is equivalent because the advertisement. So what the court said is the advertisement must be strictly consumed. It says that it has to be bachelor's degree in history. When you don't have it, you are automatically out. These are the judgments. I'll pause for a moment here, my lord. These 4 judgments, in my view, humbly settle the law that they cannot deviate from the advertisement. For a moment, my lords, for a moment arguing against myself, even for whatever reasons the internal guidelines are to be considered. Your lordship saw guideline 15, which I pointed out, saying that whatever is the eligibility criteria is to be seen on the date of the vacancy. The vacancy is on 1/8/2020. These internal minutes are of 2022. They could not have been applied. As on that day, 1/8/2020, these internal guidelines were not even in force. You cannot bring, they themselves have given the guidelines. That is to avoid confusion, because the advertisement, the gap between the vacancy and the advertisement can be anything. It can be 3 years, 4 years, sometimes 5 years in public sector undertakings. So as not to cause injustice to candidates, the guidelines say that as on the date of the vacancy, whatever is the qualification that needs to be considered. The internal minutes were not even forced as on that date. Now, my lords, similar situation in the Delhi High Court, where the guidelines said something and they relied on some internal communications even from the Prime Minister's office. Kindly see how the Delhi High Court has dealt with this. My lords, till now I have argued 2 points. One is that broadly 2 propositions that I have canvassed. One proposition is that advertisement has to be strictly complied. Once that is agreed, no further argument is required. Even otherwise, the internal minutes are not applicable for this vacancy because the date of the vacancy is 1/8/2020. Thirdly, the internal minutes themselves have no validity in the eyes of law. For that, my lords, kindly see in that the judgment number 5, a Delhi High Court had an opportunity to deal with this submission. This is V.K. Sehgal versus Union of India. This is flag number 5, my lords. Yes. The first paragraph from line number 4, just to give the context, the petitioner has challenged particularly the non-consideration of his case for appointment to one of the posts of chairman cum managing director in the subsidiary companies in Coal India Limited on the ground that the petitioner did not have 2 years of actual service remaining on the date of the interview. This was his grievance. Now, why his application was rejected, that your lordship will see at para 3. The respondents 3 and 4 have filed their counter affidavit in the instant case justifying their action in not calling the petitioner for interview. It is stated in the counter affidavit that since the petitioner has crossed the age of 56 years on 13/8/1995, he was not called for the interview to be held on 7/9/1995. In the counter affidavit filed by the respondent, the aforesaid action is not calling the petitioner for interview have been justified on the basis of the letters issued by the Department of Personnel and Training, Ministry of Public Grievance. Specific reference has been made to the circulars and letter dated so-and-so, issued under the DO number so-and-so, where it is stated that the Prime Minister had directed in the policy of placing the cutoff limit as 56 years for calling for a person for interview by the PESP should be strictly followed. It is further stated therein that the Prime Minister had further directed the power to relax age limit would vest only in the Appointments Committee of the Cabinet, and their proposals for any relaxation in the age limit might henceforth be submitted to the Appointments Committee of the Cabinet for its approval. The respondents also relied upon another letter issued under so-and-so, issued by Secretary of Department, where it is stated that candidates who would not have the prospect reasonable to. So what has happened is the issue was, as on the date of the advertisement, the person had 2 years, but as on the date of the interview, he had less than 2 years service. So relying on these circulars, they tried to say that he is not eligible. The argument is important, my lord. Just I'll take only a few. Para 4, I'll not read the entire. Your lordship may, in the next page, page 608, overleaf, from the second line, his further submission was that there is no statutory rule in support of the criteria adopted by the respondents, nor is there any guideline to that effect, and such restrictions cannot be laid down through internal letters without any publication of the same in accordance with law. This is the contention. Now kindly see what it was held at para 10. Para 10. The aforesaid two circulars relied upon by the respondents do not appear to have any statutory or executive backing, and is just a communication from one officer to the other without laying down any specific guidelines thereto. For the foregoing reasons, in my opinion, the cutoff date fixed by the respondents for computing availability of 2 years service as the date of interview cannot be said to be based on any reasonable criteria, as the date of interview is always uncertain. The PEC, then it follows, my lords, the facts. The PSP initiated their action for filling up the vacancies on 3/8/95 by calling for biodata of eligible candidates, including, and in fact, facts and circumstances in the present case, and taking the entire matter into consideration, the said date could be said to be a reasonable cutoff date of having 2 years period for the purpose of considering names of eligible officers under the aforesaid circumstances. Since on the date of the petitioner was eligible to be considered and had not completed 6 years of age, I am inclined to allow this writ petition. My lords, so my lords, the circulars that the internal, this is akin, my lords, the circulars that they relied upon here are akin to the internal meeting minutes that they are relying upon. They could have communicated it to the public sector undertaking. All of that is fine. They might have put it up in the website and all. But what is the validity of that? Have they been incorporated into the guidelines? Wait, please. Let's quick recap, my lords. Criteria adopted was contrary to advertisement. Proposition of law is clear. Even otherwise, the internal minutes that are relied upon, they are after 1/8/2020, which is the date of vacancy. Date of vacancy, the guidelines clearly say that your eligibility is taken as on the date of the vacancy. So even arguendo that those internal minutes cannot be considered. The internal minutes themselves are not legally binding with the judgment of the Delhi High Court. Then one flag number 6 in that compilation minutes, the Calcutta High Court had an opportunity to examine these guidelines, what the guidelines themselves, what is their stature, because these are not statutory guidelines, Melons. The first paragraph, the petitioner has filed the instant writ application decision taken by the concerned authority of the ministry, Coal Government of India, to recommend scrapping of the panel prepared by the Public Enterprises Selection Board for the post of chairman come managing director. This was the grievance. Now kindly see what is a relevant guideline, which is at the next page, paragraph 3. In that unnumbered paragraph 6, my lords, on 11th June 2014. The compilation of all earlier guidelines for processing of proposals for appointment extension termination of appointment to a board level post in a PSU or approval of ACC, which was already available on the website since was November 2000 was issued by the ACC. These guidelines included the guideline dated May 2008 relating to the CPSC and CPSC, the Central Public Sector Enterprises issued by the PSP. As per its terms, the validity of the panel of names recommended by PSP is 1 year. So even before this 1 year had passed, they had scrapped it, that was challenged. So this was the guidelines as on 2014. Now we have the 2017 guidelines. Now kindly see how the court considered the binding nature of these guidelines at para 19. In the facts of the instant case, the recommendation of scrapping of the panel made by the concerned ministry, your lordship may note it is a ministry, which is the higher department than the PESP ministry on 29th May 2015, without following the prescribed guidelines as contained in the office memorandum of the Secretariat of ACC dated 22nd October 2014, therefore was unconstitutional, being wholly illegal and arbitrary. Even if the guidelines contained in the office memorandum dated 22 October 2014 was not based on any statutory provision and was merely an administrative instruction issued by the Secretariat of the ACC in exercise of its executive power, such guidelines or administrative issue will continue to have the force of statute in the absence of any statutory rules regulating the recruitment process in question. In this context, Dr. Amarjit Singh Ahluwalia is a Supreme Court judgment. In this context, one may take note. I beg your pardon. One may take notice of judgment rendered by the Honorable Supreme Court in the case of Amarjit Singh Ahluwalia. It was a bounden duty of the concerned ministry to follow the prescribed guidelines as issued by the ACC from time to time, unless those guidelines were contrary to any specific statutory rules in force. Having not adhered to the prescribed guidelines while issuing the letter dated 29th May 2015, the action of the concerned ministry was susceptible to the vice of arbitrariness, which is the crux of Article 14 of the Constitution of India and basic to the rule of law, the system which governs us. On the basis of this, the decision of scrapping was set aside. This is why I'm pointing out this judgment is the guidelines, my lords, though they don't have a, they may take it because in the, yes, my lord, because in the counter, an interesting averment is made. This, which is neither here nor there. Your lordship may see para 14 of the counter filed with the vacate petition at page 7, para 14. Vacate petition, IA 3. Para 14 at page 7. Para 14. It is submitted that the first respondent published the guidelines, which are also available on the website of page 7, para 14. It is submitted that the first respondent published the guidelines, which are also available on the website of DOPT, indicating the process of selection for appointment of board level appointments of Central Public Sector Enterprises. Chapter 1 and 2 deal with composition of procedure, and other chapters deal with post of functional directions on contractual basis, which are tenure based. These guidelines are published way back in 2017 as amended time to time. And since then, almost the same procedure has been followed except for minor changes. From where do they get the power to follow it with minor changes is a question that I put to myself. They admit it in the counter. Now, why have they stated this? Because they know that what they have done is contrary to their guidelines. Therefore, to get over it, because they have to somehow bring in those internal minutes, they have to justify it, this statement has been made. And that is the reason why I'm pointing out the judgment of the Honorable Calcutta High Court, which follows an Honorable Supreme Court judgment. This flag number 7 is the Supreme Court's judgment. The principle of law is clear that in the absence of statutory rules, the guidelines which are in the nature of OMs and executive instructions, they become binding. Otherwise, the executive can function arbitrarily. In one case, I'll follow the OM, other case, I will not follow an OM. That is the basis, that is the crux, my lords. There is a para, in that judgment, para 8 and 9, I'll not trouble your lordship reading the entire paragraph. It's a lengthy paragraph. The principle is, in the absence of statutory rules or guidelines, if the department has made internal guidelines, then they need to follow it. They cannot deviate from it. If your lordship is or on that, I'll just read that, para A. But that does not present any difficulty, for it is now well settled by several decisions of this court that where no statutory rules are made regulating recruitment or conditions of service, the state government always can, in exercise of its executive power, issue administrative instructions providing for recruitment and laying down conditions of service, right, so and so. It was therefore competent to state government to issue clause 2 of the memorandum dated so and so. This was with respect to the power to issue such. In para 9, the binding nature of this, your lordship may turn overleaf, page 510, from around line 5. Now it is true that clause 2 of the memorandum dated October 25th, 1965 was in the nature of administrative instruction, not having the force of law, but the state government could not at its own sweet will depart from it without a rational justification and fix an artificial date for commencing the length of continuous service in the case of some individual officers only for the purpose of giving them seniority in contravention of that clause. That would be clearly violative of Articles 14 and 16 of the Constitution. The sweep of Articles 14 and 16 is wide and pervasive. These two articles embody the principle of rationality, and they're intended to strike against arbitrary and discriminatory action taken by the state. Where the state government departs from a principle of seniority laid down by it, albeit by administrative instructions, and the departure is without reason and arbitrary, it would directly infringe the guarantee of equality under 14 and 16. That is elaborated further. Now, my lords, they have not given a rational reason why, when the guidelines are clear, that whatever they have to advertise it, date of vacancy is sacrosanct, and as on the date of vacancy, the advertisement also does not refer to the internal meeting. The advertisement does not refer to the 3 categories. Then on what basis have they gone into the internal meetings and tried to do it? Is therefore, my lords, on this, my humble submission, therefore, is a writ petition deserves to be allowed, and the petition. Correct.
Your lordships may kindly see the notification, your lordships. I would like to start from the very first notification, your lordship, experience column. Page number 28 of writ petition, your lordships. I have also filed along with my vacate. Your lordship's experience, the applicant should have at least 5 years of cumulative experience during the last 10 years in various aspects of HR/personal management and /industrial relations in an organization of repute. It has to be read entirely, your lordship. He cannot stop at till personal management. After that, your lordships, it also has industrial relations in an organization of repute, your lordships. This also has to be read. It has to be read entirely, your lordships. And the second point, your lordship, this internal committee meetings were entirely was very much available with the website, your lordships, and it is being communicated to all the departments, your lordships, all the concerned CMDs and MDs, your lordships. It is being communicated. At the time of applying, your lordships, all the applicants were very much aware of the selection process, your lordships. Now, after applying, if he has not shortlisted, your lordships, now he cannot come and say that those are not having the qualifications and it is not been specified in the notification. The notification is very clear that the persons from the industrial relations also can be applied, your lordships. And the persons who are shortlisted, your lordships, they were working as a project heads, your lordships, in their IA. Their own IA, lordships, filed by them. Direction petition. Your lordships, where they have filed the experience of the selected candidates, your lordships may kindly see. Shortlisted. I correct myself, Your Lordships. Mr. Sahu, Your Lordships, the experience. He is working as a, Your Lordships may kindly see at page number 17. 17 is, yes, Your Lordship, Mr. Sahu. And he's been working from with the NMDC from Your Lordships 2012, Your Lordships. Head of the deposit of 10 days, so-and-so statutory allowance, renewal of mining leases, optimum leases, and machinery, risk management and preparation of training schedules, SOPs. And Your Lordships may kindly see, in the year 2014 to 16, head of production is responsible for planning, production and sales, project management at the mines, plants, mechanical, electrical. Next, Your Lordships, development secretary, state good authorities. Production of responsible for planning of production, maintenance, goods, IR, training, development, safety, licensing with the safety, state government authorities, implementation. Yes, Your Lordships, as per the notification, they have. Yes, Your Lordships, and also the respondent authorities looking for the overall experience, only not only HR experience, Your Lordships, to have a overall experience of industrial personnel management and all, Your Lordships. In the interest of the institution, Your Lordships, they have categorized from the different departments, Your Lordships. As stated in the meeting, Your Lordships, internal committee meeting. And that is being communicated, which I have filed along with my vacate stay petition on 5/8/2022, Your Lordships. That also I have filed. That communication, Your Lordships. At 5/8/2022, along with my vacate stay petition annexure 3, Your Lordships. The internal committee guidelines, Your Lordships. Selection procedure is being communicated. The Public Enterprises Selection Board. After detailed discussion and deliberation, Your Lordships got it in. Internal meetings held on 19/8/21 and 4/2/22 has drawn comprehensive process for shortlisting the applicants for the post of Director Finance and Director HR Personnel across the CPAs. The process approved by the Public Enterprises Selection Board are attached at Annexure 1 and 2. Till today, it is available in the website, Your Lordships. The selection procedure, this internal committee meeting, Your Lordship, selection is very much available in the website, Your Lordships. And now, Your Lordships, the counter has been already read by my friend, Your Lordships. How I have come to conclusion that other shortlisted candidates, Your Lordships, at para number 9, again I have stated after 8, Your Lordships. May I read, Your Lordships? With regard to the para 9, it is submitted that the call letters were issued. This is para 8, Your Lordships. In para 9, it is submitted the shortlisting of board level selection is done by the respondents, that is PESB, as per the prescribed procedure and guidelines, which is being followed from time to time. For the post of Director HR Personnel, apart from experience given in the job description, the criteria spelled out in the internal guidelines of PESB dated 4/2/2022 strictly followed. It is submitted that the said guidelines have been duly communicated to all the Ministry Department of the Government of India and CPEs while proceedings dated 5/8/2022. And the same are also available in PESB website. The PESB has divided candidates HR personnel post following 3 categories, Your Lordships. As these categories have already explained by my friend, Your Lordships, therefore, it is submitted that for the post of Director HR Personnel, which is high managerial post in the company, the only endeavor is not only to have one core HR experience as a managerial requirement, but also the candidates having the sufficient experience in senior position and having dealt human resources in their respective domain who are made eligible as category 3 and category 2. However, HR experience as per the guidelines dated 4/2/22, 3 candidates for category 1 are given preference in shortlisting followed by the category followed by category 2 and candidates and category 3 candidates. Therefore, PESB has endeavored to balance the need where not only core HR officers are available for shortlisting, but also the officers from other streams who have worked sufficiently at a senior position. Respondent number 6 to 8 were thus shortlisted basing on the guidelines issued on 4/2/22, Your Lordships, and there is no arbitrariness, Your Lordships. And Your Lordships, for this support, in support of my argument, Your Lordships, I would like to rely on the judgment of Your Lordships of Delhi High Court dealing with the same department, Your Lordships, for the very same post of Director Finance. Here is the Director Personnel, Your Lordships. There, the issue was also with regard to the same criteria, Your Lordships, where the chartered accountants and the difference between preference is being given, Your Lordships, eligibility criteria, employee status, qualification, Your Lordships, chartered accountant and cost accountant, Your Lordships. A preference has been given over the instead of chartered account, a cost accountant is being given. Chartered. Yes, Your Lordships. The relevant portion is at Your Lordships may kindly see the issue at page number, internal page number is now there, Your Lordships, para number 45, Your Lordships. Para number 45, internal page number 15, Your Lordships. Is at top. Para number issue 2, Your Lordships. In the instant petition, the petitioner seeks issuance of mandamus for quashing the preference clause prescribed in the advertisement/JD. Therefore, the order to decide the sub-issue, it is pertinent to discuss the nature and scope of the mandamus in order to understand whether this court can issue a writ for setting aside the decision of the expert committee, which stems out from the minutes of the meeting dated so and so, not under challenge before this court. In this matter also, Your Lordships, they have again framed a sub-issue, Your Lordships. Before that, Your Lordships, as Your Lordships very well knows, the scope of the mandamus, Your Lordships, I don't need to read all the judgments by troubling Your Lordships. And the sub-issue is framed at page number 19, Your Lordships, para number 56. In this also, Your Lordships, writ petitioner has not challenged that minutes of meeting, Your Lordships. He has only challenged the challenged the notification saying that is been violated, the clause is being violated, that expert committee minutes of meeting or regulations has not been challenged, Your Lordships. 56, Your Lordships. Now coming to the sub-issue 2, where the question of whether this court can set aside the decision taken by the high-level expert committee needs to be decided, Your Lordships. Based on the foregoing discussion, it is evident that the petitioners have challenged the preference clause where the preference has been given to the chartered accountants over the cost accountants. It is also clear that the said decision to prefer one set of professionals over others was taken and approved by the respondent body. The respondent body is a high-powered body constituted by the Government of India for appointment of top management posts in various CPSEs, including the respondent organization. Therefore, it is imperative to analyze whether the respondent body committed material illegality by taking the said decision. And this is again with regard to that matter, Your Lordships, whether the decisions taken by the expert committees can be set aside without there being any illegality in the constitution of expert committee. It is the case of the petitioner that there is no illegality, no such illegality in the constitution of that expert committee or guidelines, Your Lordships. They have not challenged that guidelines. And I have also discussed the various judgments of Honorable Apex Court, Your Lordship, with relation to the expert committee. The decision taken by the expert committee can be interfered by this Honorable Court or not, Your Lordship. Said para number, it starts at 60, Your Lordship. Decision of Honorable Apex Court in UPSC versus M. Satya Priya, 2018, 15 SC 796, Your Lordships. Your Lordships. Para 63, Your Lordships. Hence, it is a settled principle of law that decisions taken by such experts need not be questioned until and unless there is a clear bias on part of the experts and malified is established by adducing sufficient evidence, or the constitution of the committee is under the challenge, which is not the case of the instant petition. It also applies here also. There is no such malefites attributed to the expert committee and all, your lordship. They are only saying that that is not relevant here, your lordship. And in the final, your lordships, this writ petition is being decided in favor of the respondents by holding that a decision taken by the expert committee, your lordships, cannot be interfered by this honorable court under 226, your lordships. That is my submission, your lordship. In view of this, your lordships, procedure is being done in the interest of the institution, your lordships. As such, there are no malefites in appointing or short. It's only a short listing, your lordships. It's not a complete selection, your lordships. Short listing, your lordships, in the interest of institution taken by the expert body, your lordships.
My lord, I have a short submission, my lord.
Yes, your lordships. That is much prior. Yes, your lordships, I do agree, but your lordships, as stated in para number 14, your lordships, those guidelines were followed for every time, your lordships, whenever there is a post or vacancy arises, your lordships, guidelines, internal committee meetings will be followed, your lordships. As such, done in this case also. In the year 2022, your lordships, much prior to the shortlisting, those guidelines for selection procedure is being decided and it is being communicated to everyone. If at all he has any grievance with regard to the selection procedure, your lordships, he should have challenged that selection procedure itself, your lordships. And even in the notification also, when it specifically says that a person from the industrial management or industrial relations also can be eligible, there is nothing wrong in shortlisting in these candidates, unofficial respondents. That is my argument. I am obliged to lordship.
I appear for the fifth respondent, my lord. Am I audible, my lord? Am I audible, my lord? I am appearing for the fifth respondent, my lord. I have a short submission, my lord. Firstly, your lordship may kindly appreciate the post that is advertised is director personnel. My lord, I must submit to this honorable court what are the functions of the director personnel. Director personnel does not mean that he will only recruitment and the promotions and transfers. Director personnel in NMDC is he deals with HR department, IR department, recruitment process, law department, as well as corporate social responsibility department. All these departments are headed by the director personnel. He is the functional head of these projects. But while selecting the candidates, the PSP, the expert committee and expert body applied its mind and found that the people who are experienced not only in HR department and other departments were also considered. That's my second submission. The third submission is what is challenged is the impugned call letter, not the rules and regulations of the PSB. Your lordship knows under Article 13 of the Constitution, law includes the notifications, the orders, the guidelines, the custom and usage. Law includes that. And no challenge relating to the law is made in this writ petition. That is my fourth submission, madam. The fifth submission is your lordship may kindly see the guidelines 4/2/2022. Though the nomenclature says it is an internal meeting, it is nothing but, my lord, a regulation, a self-developed mechanism which they have developed, and they kept it in the portal in February 2022 itself. It is known to all. It is available in the website of PSB even today. And the writ petitioner, being head of HR department, is fully aware of about the modus what the PSB has decided. This modus includes, my lord, not only your lordship, important aspect, my lord, what is missed is that 10%, 1,000 personnel have to report to the functional head. That is category 2. And 20% of the personnel to be reported to the category 3, being the chief general manager of project. And my lord, the entire project reports to him, not only 20%. And the Sai is the chief general manager of the project, not chief manager as was read by the writ petitioner. He was the chief general manager of the project. And whereas the other law department and other departments are concerned, 10,000 employees will report to them. So therefore, the expert committee has applied their mind and ultimately shortlisted it a suitable candidate for an overall in charge of director personnel post. And my last submission to your lordship is that the judgments are not statutes. Your lordship may kindly note down one citation, 2011, 5 SCC 708. 2011, 5 SCC 708. Para 32. CBI versus Sushil Suri. CBI versus Sushil Suri. In this case, the Supreme Court categorically held a singular factual difference will make the judgments inapplicable to the facts of the case. Ultimately, you lordship have to see the ratio decision basing on the facts of that case. But these cases cited with the writ petitioner, they are not, my lord, applicable to the present facts of the case. In this case, my lord, it is wide open to everybody that the regulation of 4/2/2022, with whatever nomenclature it is called, it is available in the portal of PESP and it is known to all, more particularly senior personnel like the writ petitioner. When it is available in the portal, advertisement is to be read along with rules and regulations. Your lordship knows this is a special post, a technical post, an expert committee, an apex body considered and shortlisted the candidates. And advertisements do not constitute, as your lordship knows, the rules and regulations and the other regulations of the corporation. Advertisement broadly considers only the eligibility criteria. In this case, my lord, nothing wrong has been done. The writ petition is liable to be dismissed. That is my respectful submission.
It's the Learned Counsel for the PESB has referred to the advertisement, and much has been sought to be made out of the words industrial relations. The lordship's industrial relations, even going back to my law course, industrial relations is generally with respect to labor laws and how you manage the relations with the individuals. While, my lords, this point that industrial relations is not HR has not been stated in their counter at all. But your lordship, by going by their very argument, human resources, personal, industrial relations, of course, principle of Udem general will not apply to this, but they need to be read along with this. It can't be that, I will be a person who's who's into specialization in mining, merely because there are, I run the department of mining, therefore I am industrial relation. In that way, my lords, any person who's in a higher post becomes eligible to this. So on facts, it is not born out of their counter effect, it cannot be countenanced. But more importantly, your lordship may kindly see the manner in which the respondents themselves have understood what industrial relations is. Your lordship may kindly take the counter again. They've given the three categories. Kindly see what they say category 1 is. The very same para 9, which the Learned Counsel has read, your lordship may take. Para 9, those three categories they spell out, they come in the reverse order. It's a strange way of drafting. Category 3 comes first to 1. 1, they say, is priority to applicant with 5 years experience during the last 10 years in HR, IR and personnel. Category 2 is minimum 2 years experience in HR, IR, personnel, plus 3 years as a functional head of projects, plants having direct responsibility. Category 3, applicants having experience as functional head of projects, plants having direct responsibility of at least 20% of the workforce. They themselves have delineated between individuals who have HR, which they understand as industrial relations, and persons who are functional heads, and then kindly see the explanation they give further below. Therefore, it is submitted that the post of director HR person, which is a high managerial post in the company, the only endeavor is not only to have core HR experience as managerial requirement, but also the candidates having sufficient experience in senior position, having built human resources in their respective domain, who are made eligible as per category 3 and 2. They separate between category 3, category 2 and category 1, and they say category 1 have taken 3 candidates. Your lordship may further see, however, HR experience as per guidelines dated 4/2/2022, 3 candidates for category 1 are given preference in shortlisting, followed by category 2 candidates and category 3 candidates. If the argument of the Learned Counsel is to be countenanced, what they are saying category 1 itself includes persons from the HR, not only includes persons from the HR department, but also from other. But their understanding is contrary. Their understanding is category 1 only is HR department, but because we want people with experience, therefore we have delineated category 2 and 3, which is other than those with personal and industrial relations. Therefore, this is the main submission. So this submission cannot be countenanced. And if on the other hand, their argument is to be agreed that in the advertisement itself, industrial relations is included, that's an admission of the fact that the minutes are not binding. Either way, my lords, that argument goes, then the judgment relied upon by the Learned counsel, my lords, your lordship may see the challenge in that was to the advertisement itself. Your lordship may kindly take that judgment. That judgment, the judgment relied by the learned counsel for the respondent, the Delhi court, Ruchir Agarwal versus Public Selection Enterprises Board, kindly take para 4. I'll just point out how the judgment has no application at all. What is under challenge there, what is under challenge here are completely different. Para 4. The said advertisement JD prescribed eligibility criteria. The eligibility criteria is extracted below. The applicant should be a chartered accountant or cost accountant or a full-time MBA PGM with specialization in finance. This is the qualification given. Now kindly see what was the petitioner's grievance there, which your lordship will see at paras 10, 11 and 12. The learned counsel appearing on behalf of the petitioner submitted that the decision taken by the internal meeting whereby the preference was given to chartered accountants or cost accountants is arbitrary and contravention of settled principle. It is submitted should have been given preference over shortlisted because the petitioner complies with all the as prescribed in the advertisement. Is further submitted is candidate is shortlisted for the job or junior to the petitioner and are shortlisted only on the ground that they are chartered accountants. She was a cost accountant. Her grievance was that only chartered accountants were there. That's how she challenged the advertisement itself. And in that context, whatever is the principle was laid on. In this context, I am not challenging the advertisement. I am saying you follow the advertisement. Therefore, my lords, that is not tenable at all. Then, my lords, the argument saying that the same procedure has been followed since long, because there is illegality for several years, when the question comes up, your lordship will always look at it afresh. If there is illegality earlier, that does not justify continuation of this. So far as the counsel for the NMDC is concerned, my lords, the submission that are made on facts, saying that personnel will do all these functions, no counter has been filed till date. Counter has not been filed from where this oral submissions, how can that be countenance? If I had brought the counter, I would have had an opportunity to reply saying that what their understanding of personnel is, whether it is right or not. Secondly, what is most important is, my lords, NMDC in this whole exercise is supposed to be a neutral body. While it is an appointment to the post of NMDC, it is supposed to be a neutral body. That is the reason why the entire gamut of selection is given to a PESP. Now, as if, this wakalat is being held for respondent 6 to 8, arguments are being made, but that is their prerogative. Maybe there is an urgency, but if there is an urgency, the endeavor must be to see who is the person who is actually eligible. That has to be taken into account. Then, my lords, the argument that the instructions, the instructions, the internal minutes, though they are framed as internal minutes, they must be treated as minutes. That has no basis, my lords. Have even pointed out judgments that they cannot be countenanced because it's an internal meeting. When the guidelines are there, unless they've incorporated into the guidelines, they cannot be binding. I pointed out the Delhi High Court judgment and the Calcutta High Court judgment. Even otherwise, my lord, the argument that as on 1/8/2020, those internal minutes are not there and their own guidelines, they have not amended those guidelines, which say that, whatever it is, the date of vacancy is sacrosanct for eligibility. That has not been answered at all. Therefore, my humble submission today, my lords, is if, my lords, as far as the dilemma, the petitioner, if he is given an opportunity to participate in the interview, when they have conducted the interview on that day, despite the order of the court, there is no harm for them to conduct an interview. Your lordship asks an order to conduct an interview tomorrow by having the petitioner and doing, there will be no further delay, so there is no prejudice caused. Therefore, my lords, the writ petition deserves to be allowed.
But I would like to give a short rejoinder, my lord, one-line rejoinder. I'm grateful to the learned counsel for the petitioner for educating me. I have raised a specific objection that where from he got the personal files, being HR department head, where from he got the personal files of other employees. There is a judicial order by your lordship that you should disclose in the affidavit. He has not done so, therefore I have not filed a counter. But in any case, I'm grateful to lordship for the patient hearing.
My lords, I have also furnished a note along with the judgment for your lordship's convenience. All the propositions that I have argued are in that note.
Yes, I am obliged to. He also is not adjournment for filing. No.
Well, JD is option 50, 40.
My lord, my lord, I beg to represent Thomas F. My lord. My lord, we filed the vacancy petition and counter also. The matter may be posted for final hearing. Much of it.
Yes, first I filed contempt and they have made tickets. We signed it. Till then he last.
Last occasion, my lord, your lordship was pleased to grant stay, my lord, and director has to get instruction. We received instructions. Yes, my lord. What of respond, GP. The first page, last portion, my lord, with regard to the allegations, my lord. The progressive complaint has been filed by the my lord, with regard to that, my lord, second page, last portion. Of the Usha, the then secretary, Pacha secretary, so and so, was issued a show cause notice on the findings of the inquiry officer, and by letter 6523, the individual has requested for handing over connected records to her so as to submit her explanation to the show cause notice issued to her. As per her request, the MPO was directed to hand over Xerox copies of connected records to her, and she was directed to submit explanation within 7 days from the date of handing over the records. Further, letter so and so 2823, the Mandal Panchayat officer has reminded Usha petitioner once again about her being directed to collect the relevant records within 5 days from him, which was acknowledged by her on 18/7/23. However, in spite of lapse of around 40 days, no explanation is received from the above said individual, which is clearly shows her negligence and non-seriousness towards her duties. It also proves that she does not have anything to submit on the findings of the inquiry. Which couple that but she was kept under suspension. That is the reason lapse was. The it was he went through MPO, no? Yes.
For R8 and R8.
Whether notice is ordered or not, I am not aware. Because on the last occasion, it was urgent for instructions. Yes, sir. Yes, sir. Yes, sir.
But I for R8 and R9 money, but precisely in mind.
This is Martin. The director consider the case and master point on the 6th. Subsequent balance sheet recovery consider the notion of after answering the objection have to be considered. He was admitted to duty with effect from 23/9. Kindly turn to the next page.
This is marriage. But the notification and the reward to the complete promotion. Everybody asked. It to me. This is the confined between the zero vacancy of the career. Without the defense. Subsequently, that will formula and it seems it. That's why they relate. Nominal ultimately, they have admitted the promotion. This criticism was started person subsequently the top of the last started now the result vector of the okay. Yeah, not the system. That's what kind of the language will be. That the last around the equation. We have a very HIGHCOURT the commission address the mistake. Under the provision is something must be on the Telangana training service. Before it is proposed to the Indian panel, without also, this are the party before any other building is brought. Okay, say, purposes are to continue talking for relaxation, so. Sorry. Well, the time.
My friend is well aware, my lord, even for giving notion from. Yes.
There is a, another the court, the authority, given by anyone. Again, let considerable length of time. They are saying.
Yes.
No, not in the thing.
Writ appeal, my lord.
In fact, the contempt is concerned, the majority. Now that the reason by decision with the pain, by anywhere last pay, judge rather some time in my time. Otherwise, they won't comply. They start with the GP. They are that is the reason. Answer like complaint issue. Yes, sir. There is last take for that.
Here, my lord, your lordship, finally, yes, yes. Yes, no, anyway, we have to comply now. There's no option. We have to comply and oblige the orders. My friend should feel happy, like he's got promotion. I'm not saying that because of your lordship's order, my lord, confirmed by the division bench, my lord, now we have promoted him. But the procedural thing will take some time, my lord. That we have to give objection, though it's your lordship may say 6 weeks, my lord. Ultimately, justice is done, my lord. See, the pensioner is a visionary state, he fought for so many years, and now he's getting the promotion. No, I'm not saying anything on that. No. Yes. Yes.
It's a fourth or fifth division, right?
Very good. Same caption.
May I please lordships in this? Out of file, Millard is seeking relief. Millard is like principal secretary allowed us to letter to the GHMC to file an SLP. Millard is to be consideration. Millard, basing on this counter lordships in this lordship kindly permitted. Millard page. Direction. Millard is regularize the services. Millard in this.
3rd August 22.
Modify the.
It says a person has to be considered if there is a vacancy to that extent, and the presumption is that there was a vacancy.
Writ appeal, my lord, is not insisting this supernumerary post, my lord, in this. Lordship kindly permitted, my lord. Lordship kindly permitted, my lord, my counter affidavit, my lord, is page 18, my lord. Lordship kindly issue the, my lord, is 21/11/2023, my lord.
For bring up for appearance, my lord.
Lordship, appearance, my lord, dispense with us. Lordship kindly permit dispense with also file, my lord, is a counter, otherwise, my lord, appearance, my lord, counter file, my lord, this matter, my lord. Now, my lord, this lordship in this
Lordship in this dispense with also filed, my lord, it's a sake of it, it's a, the officer, my lord, is appearing before this election, the urgency meetings, my lord, this.
Yes, my lord. But subsequently, your lordship said for compliance or appearance.
Lordship,
That was
lordship kindly counter, my lord, we file counter, my lord, lordship kindly permitted me. 7th November, no, my lord, 7th. Compliance, my lord, 7th November, my lord, is a job.
I'm number 54.
64.
You're not a.
Applying dismissal carriage up time. Taking.
Yes, yes, ma'am. Yes, we are both are here. Yeah, you can ask for question about a point. Yes.
Your lordship, 62. Your lordship, item number 64. Attempt is, initially it was a hard, partly hard, check is not filling well, 1 week time.
52, 53 also heard. 51, 53.
Next week,
Next week. Reference is.
My lord, item number 56, my lord.
64.
Yes.
Much of this.
Item number 56, my lord.
Yes.
Extension of interior model, my lord. If lordship so pleases, my lord, counter not filed.
Let I. Item 63, may be closed with Miller. Contempt of filed against the item 66 Miller. Yes, Miller. Main bit petition, sir. Yes, your lord. Petition. Main petition is closed on 13/10. This contempt is filed against the interim order. CR. CR.
My lord, your lordship posted to next week. 52, 53, I am seeking 4 weeks time, my lord. Council is here. 50. Yes. Yes.
కంపెనీ ఆఫీస్ ప్రెసిడెంట్ కదా. హలో అదే అర్జెంట్. హలో ఒకసారి ఫోన్ ఇవ్వండి. హరీష్ నీ ఫోన్ ఇవ్వండి ఒకసారి. హలో వస్తుందా ఒకసారి చూడు. నా 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 నేను కనెక్ట్ అయినా కదా ఇప్పుడు. ఫోన్లో వినపడుతుంది. నా వాయిస్ నీకు వినిపిస్తుందా? ఫోన్లో కాకుండా బయట రెండు వినపడుతున్నాయా? మైక్ లో బ్యాటరీస్ ఎలాగున్నాయో చూసుకో తీసేటప్పుడు. మళ్ళీ వేరే మైక్ లో నుంచి తీసి అక్కడ పెట్టు. నీకు అక్కడ గ్రీన్ కలర్ బ్లింక్ అవుతుందా ఓబిఎస్ దగ్గర? నువ్వు వేరే మైక్ దగ్గరికి వెళ్ళి మాట్లాడు. అదే ఇప్పుడు అడ్వకేట్స్ మాట్లాడే మైక్ ముందుకు వెళ్ళి మాట్లాడు. గట్టి మాట్లాడు. హలో లేదమ్మా వినిపించట్లేదు. అస్సలు వేరే మైక్ దగ్గర కూడా వినిపించట్లేదు. ఇప్పుడు నేను మాట్లాడేదైతే మీకు వినిపిస్తుంది కదా క్లియర్ గా? సైడ్ నుంచి వాళ్ళకి వాయిస్ వెళ్ళట్లే. ఇప్పుడు ఇప్పుడు వస్తుంది. ఇప్పుడు నువ్వు మాట్లాడి క్లియర్ వినిపిస్తుంది. ఒకసారి నువ్వు అక్కడికి వెళ్ళవా? ఏది జడ్జి గారి సిస్టమ్ దగ్గర నుంచి మాట్లాడవా? ఇప్పుడు నువ్వు మాట్లాడుతున్నావు జడ్జి మేడం దగ్గర నుంచే మాట్లాడుతున్నావా?
అవునండి.
ఇప్పుడు నాకు క్లియర్ వినిపిస్తుంది.
ఓకే ఓకే డన్ అయితే.
ఓకే అట్లనే ఉంచు. ఇంక నువ్వేం గెలక దాన్ని.
ఓకే డన్.
ఓకే రైట్. నువ్వు ఏది సీన్స్ వేసేటప్పుడు మాత్రమే ముట్టుకో. ఇంకా సీన్స్ మాత్రమే ఇప్పుడే లంచ్ బ్రేక్ అని ఇప్పుడే సీన్స్ ఓబిఎస్ లో వేస్తున్నావా? హలో హలో ప్రవళిక గారు హలో
అయ్యో రఘు సార్ వినపడుతుందా?
వినిపిస్తుందండి. ఇప్పుడు క్లియర్ ఉందా?
క్లియర్ గానే ఉందండి.
వాయిస్ వినిపిస్తుంది, మేము కూడా కనిపిస్తున్నాం కదా క్లియర్ గా.
అవును.
ఇప్పుడు జడ్జి సార్ సిస్టమ్ లో ఏముంది? జడ్జి మేడం సిస్టమ్ లో
జడ్జి మేడం సిస్టమ్ లో ఇంకేం నేను డిస్టర్బ్ చేయట్లే, ఉన్నవన్నీ అవే సెట్టింగ్స్ ఉంచేస్తుంది.
ఓకే, అక్కడ మ్యూట్ కనిపిస్తుంది కదా. ఇప్పుడు
అవును.
మీకు గ్రీన్ కలర్ కనిపిస్తుంది అక్కడ.
అవును. గ్రీన్.
వీడియో ఏమో అందులో కనిపిస్తుంది.
అవును.
ఓకే రైట్.
సో అది సెట్ అయినట్టు అంతేనా?
ఓకే, ఇప్పుడు టీవీలో ఏం కనిపిస్తుంది అంటే ఒక సైడ్ ఏమో జడ్జి మేడం కూర్చున్న సీటింగ్ ఒకటి, ఒక సైడ్ ఏమో నా ఫోటో కనిపిస్తుంది, అంతే కదా?
అంతే.
రైట్, ఇంకా క్లియర్, ఇంకా మీకేం ప్రాబ్లం లేదు, క్లియర్ ఉంది.
థ్యాంక్ యూ.
ఓకే రైట్, బాయ్.
Item number 54, presentation of list. Item number 54, Amman, Sir Abbas, A. Metropole. Item number 55, HIGHCOURT, A. Jagat. Item number 56, organization of
Millard, I'm sorry, Millard. Millard, extension of material. I'm sorry, Millard. Extension of it. I'm sorry, Millard.
item number 78 and so on.
I'm appearing in this matter for respondent. Actually, the matter is posted for filing and we kindly post it next week. For final hearing, the order needs to be so that it is posted for final hearing and the papers are not served on us by the petitioner's counsel despite making requests. Next week. For final hearing, the order needs to be so that it is posted for final hearing. Not served on us. Petitioner's counsel despite making requests.
Yes. Item number 78 and so on. Item number 59, Gaurav Agarwal, Praveen Kumar, partial personality. Take application so online. If you know when you any application. Thereafter, we check the prepaid refund, then we intimate the balance. This is the reason you are applying save on the yeah, it's for other people.
There is an order.
This is the detail. Post election. No, my lord, in the last occasion, when the direction is given, my lord, by implementing the fourth respondent, Sumoto, direction is given, my lord. Subsequently, this court observed that, my lord, the order copy is not marked to the respondent number 4. Thereafter, my lord, the amended copy has been issued, dispatched, my lord. Subsequently, it was noticed that, my lord, the fourth respondent, though implemented Sumoto, he is not party to the contempt petition. No, it was directed to make implement petition, my lord. The implement petition is also filed, you know. A number, no? Yes, yes. Notice has to go to the fourth respondent. Yes, ma'am.
Item number 64, adjourned, item number 65, sorry. item 61.
Arjun.
Without informing me. It's morning to Millard, I am waiting for this. Next week, did you?
Oh no, that's
Private responded to Mahindra Reddy. Big Mahindra Reddy.
This matters, item 65 and 66, Miller. These are against the orders passed by lordships in the interlocutory order. Now the main writ petition. That is what main writ petition, both writ petitions are disposed by common order. In view of that, nothing remains in the contempt. Yes. The court order. Both the writ petitions are disposed of. Directing the parties to the arbitration proceedings. Arbitrator was already appointed. Standard.
That's gross violation of this court's order. Just explain the form of the law. And the police has high-handedly supported the they have plugged the
Now the interim order merges with the final order, nothing to remain.
Hello.
Yes. When lordships are not dealing with the contempt, where the vacate petitions are pending. Yes. The temporary measure lordship granted an interim status connecting both the parties that protected the interest of the both the parties.
This one also, but the management supported them taken the.
Now the merits of the matter, that is before the arbitrator. Yes. Problems.
Item number 67. See the article.
Also, may kindly grant 4 weeks time, Lord. The collector has addressed a letter to the CCL, Lord, seeking consent, Lord, with regard to the compensation appointment because the post is.
Item number 68. Item number 68 is posted. Item number 68 adjourned. Item number 7. One second. Yes. Item number 71. That's not all.
Item number 73, 50, services one.
But page 9.
Cancel area, there, not
Cancelled, Miller. Your Lordship's direction is a positive direction that was granted on 15/6/2023, directing the respondents to continue the petitioner Bonakal until further orders. This order they implemented after filing contempt, after issuing notice 6 months thereafter. When there is a positive direction, they cannot ignore unless I file contempt. It cannot be the tendency. But that tendency is to be condemned. Because they implemented the order after 6 months, they are saying we have complied. Is it a compliance or not? It is only the question. But they have no choice, Miller. They have to file a vacate and argue the matter. But after 6 months, they have taken their own time. Meanwhile, they pressurize the petitioners in various methods because this is a uniform service. Since though this person belongs to lowest rank, he just tolerated all this and he stand like this. Otherwise, he would have been withdrawn the writ itself. 6 months, why they have taken time? That is only, otherwise I leave it to Lords. Firing contempt.
29 issued on 15/6/2023. Petition on 29 September.
This
15/6/23.
15/6, I communicated on 21/6. They implemented Millard. But this interregnum period, he was out of employment, the salary and everything, these problems will arise. He was an heir, Millard. In this interregnum period, he was an heir. There is no posting, he was not permitted to continue. He will ultimately, Millard, he will be put on loss for the salary. It is all their conduct results all this, Millard. Let them pay the Millard. If they want to implement, let them implement honestly by paying the salary. Pardon me. If it cancels, Millard, it goes back. I reported. But once it is cancelled, it should go back to the date of order. But they should, ultimately, these 3 or 4 months period of salary, since he was not permitted to continue in spite of the positive direction. Ultimately, they will treat it as a loss of pay or whatever. Again, another litigation they will also. Why? Not suspended. Not suspended. Positive direction to continue.
Is not expecting the officers to take immediate steps, whatever steps they want to take, but somehow they are taking proper action. Already Rashida several times and some cases.
Lord, this matter, my lord, last occasion, they took time for 1 week, lord, for compliance. It's a, my lord, that order was passed 1 day suspension, next day termination, has been suspended.
10th class memo, 10th class examination marks.
It's contrary to the CCA rules, my lord, it has been suspended.
So conducting any.
Lord, the termination
First
order.
appointed for the. First one. You.
DO passed the order, has been suspended.
In this matter, speaking order, is passed now 17/11/22. Not 317, you know. It's rejected. Seventeen, 11/22. There is a order from the copy of the government is directed to be communicated through the DM and HO. Please see. No, I am giving.
Next week. Right number 76.
Please, your lords. The contempt filed against the fourth respondent for non-compliance of your lordship's order 24th July 2023. Your lordship simply directed to comply the GO which was issued by the government in regard compensate appointment. Simply he says at belated stage transmits the GO to the CEO and he shows the burden on the CEO till the time of 26/9/2023. His not passed down.
CEO, जिला परिषद is the complete. CEO you got to be one in first way, arrange the one. Second you got to be one.
CEO also party respondent to the writ proceedings, my lords.
CEO you got. CEO जिला परिषद first. CEO one in first. Because both respondent is not the complaint authority. CEO is the address given is respondent. You got along with counter if I not. Page 7 is lost. They also because address is lost. And if we inform with the annual country numbers, delivered judgment, without the able to support it, we can back up to direct to from the country. Seeking compliance from the accordance to given national laws, was after the as per the history informed that it is surface data third side already the third side the proposal of submission again to you in respect of email from now control number 67 so seeking compulsion appointment with the request to take further action in the matter. Yes, so in the government news, one eight you say again that again second reminder because it's not the complete proximity.
We have made, he is already party to the proceedings. Fifth respondent here and there. Fourth respondent DO, my lords. Fifth respondent is the party. We made a representation to the CEO also, my lords. I understand, my lords. I understand. Obliged, my lords. Basically, the GO is transmitted to all the respondents. At least they would have considered the compensate appointment since long from 3 years. For the reasons best known to them, they are dragging the matter. In spite of your lordship caution, they simply throwing from pillar to post, my lords.
EO is the company only to teachers to us. Now he say he has the appointment winner the state. Winner the state it goes to CEO in them. Forward.
Obliged, my lords. Obliged.
My lord, the revised pension withheld for the last 3 years, they are recovering the amounts, my lord, of difference already. And they have not paid till that, they have not complied with that. But the direction is not to recover any amount, my lord. Without authorities, clear violation of this. No recovery can be made such some sort of retirement. They are recovering still, my lord. They are not paying the. For the last 3 years, my lord, revised pension has been withheld and recovering amounts, those amounts, difference amount. Actual.
This is our wages of accepted also. This is the order. This is amendment order. And when it's subject to attention has been reduced from 40 to 45 to 35. They just did it in this. This is amendment order. From the accounting general or for. What is provision? Yes. It is 65% to 35. Yes. 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 But this you do second. So can do should be among the not thank you not considering it is not given. Mainly puts the control. Willard, they have not recalculated the pensionary benefits. Only retirement benefits they are. Pensionary and retirement benefits. It is within the. They are not recalculating pensionary benefits. Government. Social services 5. Yes. Actually, the value of this brand. Because of other some time groups. Here are with Lisa only. Page 16 operating. Willard, your lordship has directed the respondent to pay the salaries, but whereas they refused to pay directly they issue the proceedings.
Copy ఉందా సార్? కాపీ ఉందా అది ప్రొసీడింగ్స్ సరే
directed to pay the salary to the petitioner as per her entitlement. Milord, I through Milord, council only Milord, I received Milord. I request your lordship to take up this matter next week, Milord. I will get instructions. Milord, lordship may kindly accommodate a date, Milord. I will get instructions next week.
May I please, my lord? I'm appearing online. I beg to represent Mr. Venkat. My lordship, hello. My lordship, your voice is not so clear, my lordship. Your voice is not so clear, my lordship. My lordship, the country.
For that 2 weeks time is that. Notice has been ordered that. Last week the match came up for hearing, personal notice had to be like, gave it as there, gave it is there. Due to that reason, division page personal notice. That is the reason notice has been issued with personal. Another person for the notice.
There is no statement. Second thing, the interest has already been taken care of by your lordship.
This is only a request next week or any date, Miller. As a technical problem, there's also starting a position talking about the technical problem. That is the reason I'm making mention. There is no machinery. As per the next week, Miller, I'll report. Yes. 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 So maybe we reporting consumer has one undertaking that not regulate the property. 1 week Miller. 1 week Miller out. I will report before Miller. By the time it's next date of hearing will not complete. By next date of hearing, not complies, Miller simply report next week Miller. Both respondents. Yeah, I think we have to do the tribal content and the material and record this 4 points that in the case.
Sure, this case, your lordship may kindly see in first round, second round, third round, all the cases were considered pursuant to your lordship's orders in contempt. This is a subsequent case. In fact, Lord, in all subsequent cases, your lordship directed them to consider their representation. This is not one such case, my lord. This is regarding, my lord, instructions, my lord. I have, in fact, there's an order. It's in. We'll intimate, my lord, your lordship may kindly grant. I have advised them, in fact, my lord, this is the second batch of case. There are where your lordships granted different directions in respect of the, because I specifically requested that there are no vacancies and beyond the notification, all the vacancies have been filled up as a special case because of the contempt spending from so many years. You know, the government took a decision, my lord, for implementing and implemented. All those persons have been appointed. This is after that, the persons who have left over, not they filed, they started for. No, no.
In this case, they are written, for good I submit the document. In the of the records, pertaining to the equipment day on content basis, as per the notification given to see so five candidates. This has secured more marks than this than the some other terminated pre-appointed candidates in terms of 0 marks number 227. Data number 9, 10, and the marks of details are given below. After they have secured more marks, they are admitted. And this in complaints of the orders of the 100 court, Hyderabad dated 3/2023, issued in WP number 17 and the judgment passed the WP number 38060 and that it is informed that the petition WP number 17 marks of some of reappointed candidate was secured more marks than the candidates. Reappointed. As per QMS, but it is not feasible to the request of the petitioner herein, but consideration of appointment as MPHA on contract basis till the final outcome of the WP number 38060 of the. You are also very clear on the 38060 is not coming in the way of appointment of students candidates. Here they were appointed on the basis of 38060, even though the file before this court banner, there has been appointment. They accepted that we have sent more marks.
Yes.
Lord, in this case, as earlier also, Lord, I have requested your lordships that they stand on different footing. These petitioners, Lord, were never before the courts. After 25 years, Lord, they already the notified vacancies doubled, Lord, were filled up. That's 2002, Lord. No, they are not. In fact, what happened, Lord, is the notification will be restricted to particular some vacancies will be notified. Merit will be with reference to the notification and notified vacancies. Now that because of one particular interim order in the year 2015, it went beyond the notification. All those matters were seized up by the division bench. Despite that, when because of all 20 years they were before the courts agitating the litigation, this honorable court took a view, that they have to be considered. Now these persons, there were no courts, in fact. That is what, I have advised the department to communicate an order. I am by the next date of hearing, I'll 3 weeks. Now election, they are not even responding to our calls.
They issued proceedings, leading up. stipulation.
Who issues the lordship? Any lordship, to contempt came in only collector as a party lordship. Earlier, the respondent was working at Nalgonda lordship, Harinagar. Harinagar, now you are transferred to Nalgonda. Moreover, collector is nothing to do with the promotions we lodge. Moreover, here issue is consider their case as per GOMS number 5 lordship, recent GOM lordship, promotions, the post of available in lordship are whenever they should have BEd qualifications and TTU lordship. Lordship has been directed to follow NCT regulations lordship. Here lordship petitioner is as per my instructions lordship, collector sent the instruction lordship. Do not have here they made only collector as party lordship. Collector as a party lordship. Collector has nothing to do with the lordship. Moreover, he has transferred to now Harinagar lordship. Harinagar to Nalgonda, he is no longer the collector of Harinagar lordship. Yes, sir. Yes, we have. Our respondent is the complete lordship, but they made 4 respondents. Will not resolve your B5 file counter, they not say will not. It's complied in lordship directly on lordship page. Consider representation, page 17 in lordship. Mutual regarding mutual transfer with that. They made a representation, document. Here it is quoting of the opinion that we apply. No, it was full of considered and was order. Now, rejected in lordship.
చెప్పేసి
Page 2 is a relevant to para 7. As per para 12 of GOMS number 21, index 2 to 22 minutes as per the employee can give consent only to one employee working in other local cadre for mutual transfer. In case of multiple consents, all such applications shall be summarily rejected. He was initially given with one employee lot. Later he opted for another employee lot. The GO says that only one. This was not directed to not may read the not para. I not me one second. Direction para 5 got one moment to last. This 14 of the opinion that if an employee has any grievance with regard to his service, he may make a representation and authorities have to consider and process the same in accordance with law and in light of the relevant guidelines in the issue. In these circumstances, as per GOMS number 21, and cannot be said that request of the petitioner should be shut out completely without any remedy. Particularly, if the petitioner has made a request earlier online and within a fixed period, but it could not be processed due to reasons which cannot be attributed to it. In view of these circumstances, court will be fit and proper to directly first-hand respondent to receive the representation of the petitioner filed in physical form and consider the same in accordance with law within a period of 3 weeks from the date of discovery. GO Lordship 21 clearly states that Lordship only one The lordship has not passed. Yes, they. In those circumstances, in those circumstances, lordship was directed to give to representation lordship. Yes, we have the same lordship. Para 50 is the direction. Para 5 is the direction lordship. When para 5 having regard to the rival condition of the material on the card, this court finds that geometry number date until I'm reading. Having regard to the rival contentions and the material on the card, this court finds that geometry number 21 dated has been issued for conversion grievance of the implies for the allotment to new local cadre. Certain guidelines were issued under guidelines number 13 of the said below. Unless under which an application for mutual transfer can be made, if we see that granting of interim orders by this court in certain situation has resulted in one of the applications withdrawing our candidature on our acceptance for mutual transfer with the petitioner hearing. It is submitted that the neither petitioner has therefore submitted another application for mutual transfer after only another bidding person. This court is of the opinion that if any employee has any grievance with regard to his service, he may make a representation and the authorities have to consider and process the same in accordance with law and in the light of the relevant guidelines on the issue. This circumstance, as per the GOV number 21 TSHC also, cannot be said that the request of petitioner should be shut out completely without any remedy, particularly since petitioner has made a request earlier online and within the prescribed period, but it could not be processed due to reason which cannot be attributed to the petitioner. In view of this circumstance, court deems it fit and proper to direct first and second to receive the representation of the petitioner, find in physical form and consider the same in accordance with law within a period. The prosecutor direction to receive the application and consider as per law. Now we will actually have passed these orders to the operative function only to receive the application. That's law.
Second number 88 says Venkataraman Suti. Please be assigned. Item number 89. Data plus.
Please, Your Lordship. But in this contempt case, respondent willfully disobeyed the orders passed by this honorable court in WP number 42669 of 2022 dated 2/12/2022, my lord. Much obliged.